Hi everyone, my name is Bhashini here. I am an estate planning and business law attorney here in California, and today I'm going to be talking to you about estate tax and gift tax. So before we dive in, let's first discuss the disclaimers. I am an attorney, however, this video is intended for informational purposes only. It does not constitute legal advice, and the primary reason for that is because depending on your individual situation, the advice can change. So please, before you take any action, do stop, pause, call an attorney in your state and talk to them about your particular matter, because as we have discussed in previous videos, estate planning is state laws. State laws apply to estate planning. So depending on which state you're living in, the advice is going to change. I'm only licensed to practice law in California, so I'm going to be focused on California law. That being said, let's dive in. So you probably have heard about the estate tax and the gift tax and don't really know how these two tax work together, or the fact that they do in fact work together, and what the exemptions are and what's going on with them is often discussed by politicians in the news, but rarely is it explained in plain terms. So that is going to be my goal today, to explain what these things are. So the estate tax is a tax on money that you're giving away after you pass away. So this not just liquidated assets. You're talking about all assets that you are passing on to someone else at the time of your death. Estate tax in the United States is taxed around, at the federal level, is taxed around 40%. So it is a hefty price to pay for giving away things to your loved ones at the time of your death. Now, that being said, in California, some states do have a state level estate tax. In California, we do not. We do not have a state level tax. So we are focused on that federal level estate tax and the exemptions that apply to that. So prior to 2018, what we had was an exemption that was set at $5 million for an individual, $10 million for a married couple, and adjusted for inflation. So it's adjusted upwards for inflation, which basically means that if you are an individual at the time of your death, you could give away $5 million worth of assets without your estate being taxed. If you were to die, and adjusted for inflation, so it's a little more than $5 million. But let's work off of the $5 million number because it's easier on math-wise for me. But let's say at the time of your death, you're unmarried, you leave behind an estate that's worth $6 million. That initial $5 million will be given away without incurring any kind of an estate tax. The remaining $1 million is what you're going to be paying, your estate is going to be paying as far as estate tax goes. In simple terms, that's what it means. Now, there might be ways that some of this can be avoided through creative tax planning, through a variety of options that may have been given in the trust documents that you have created or estate planning documents that you have created. But in general, that's just how that works. Now, a gift tax, because there are the people who say, well, that's fine, I'll just give away everything during my lifetime. I'll give it away, and that way I could see my loved ones enjoying it, and I could bypass the estate tax. However, the government obviously have thought of this option as well, and what they have created is a gift tax. The way the gift tax works is that every year there is an exempt amount that you're able to give away without incurring a gift tax. That amount in 2020 is set at $15,000. That number changed from year to year. So you want to look at what is that amount every year so that you know at what level you can give things away. With the gift tax, that $15,000 is not an aggregate number, it's per person. So let's say you have 2 kids and 4 grandkids. You could give each of your kids $15,000. You could give each of your grandkids $15,000, and you won't incur a gift tax if it's 2020 when you're doing this. So you want to pay attention to what that number is, and then especially if you have an estate that's worth a lot of money and beyond what the estate exemption tax is, you probably want to spend down your estate a little bit during your lifetime by doing these gifts to your loved ones. Now, let's say it's 2020, you have 2 kids, and you give the first child $15,000. Great. You're within that gift tax. There isn't an additional amount that's impacting this equation. But your second child, you give them $20,000 in 2020. Now you have given $5,000 in excess of the gift exempt amount. So you would want to talk to your tax preparer, whether that's a CPA or an accountant, and ask them for advice on how to report this and the filing that you have to do, because there is a filing that you need to do. But basically, that $5,000 that you gave in addition to the gift exempt amount is going to count toward the lifetime gift amount that you are able to give away. That lifetime gift amount is equivalent to the estate tax. So basically, it is tied together. It is not that you could give away up to $5 million during your lifetime in excess of the gifts amounts and $5 million when you pass away. Is that you have $5 million in total to give away. So if you're using the gift tax correctly, you're going to give up to the gift exempt amount and nothing more than that, because you don't want to start deducting from the estate tax amount that you are allowed to give away. So keep that in mind. Those numbers need to match up. So let's say you're in a situation where you have $6 million and the gift amount for 2020 is set at $15,000. And the estate exemption is set at, in 2020, is set at $11.58 million. What that means is that you are giving away $15,000 this year to whoever your beneficiaries are that you wish to give money to. You're giving them those amounts. Your goal is to spend down. I said 6 million. My numbers are not adding up here. So let's say you had 12 million actually to give away. You're an individual who's unmarried. You have $12 million to give away. The estate exemption for 2020 is 11.58 million, and the gift exemption is at 15,000 for 2020. What you're trying to do is bring your estate amount below the estate tax amount. So you could give away money during your lifetime up to the gift exemption and basically spend down your estate. Now, you might be wondering, wait a minute, Bhashini, how did you get from 5 million to 11.58 million, even adjusted for inflation? That is a big number. That is because I forgot to explain this part to you guys. In 2018, there was the Tax Cuts and Jobs Act. And what that law did was it doubled the estate exemption amount. It went from 5 million for an individual to 10 million for an individual, and from 10 million for a married couple to 20 million for a married couple. So really, it doubled everything. And you might be thinking, well, that's fantastic. I could give away more money. Only caveat is that there is a sunset clause attached to all of this. The 2018 Tax Cuts and Jobs Act said that if you passed away between 2018 and 2025, you get this higher exemption. However, Congress has to act in order for this higher amount to stay at that higher amount. Because if you were to die in 2026, we actually right now do not know what the state exemption will be for someone who dies in 2026. So if Congress doesn't act, if Congress doesn't choose to keep this number at this higher number, at the higher exemption, then everything reverts back to pre-2018 Tax Cuts and Jobs Act amount, which was the 5 million and 10 million for couples, adjusted upwards for inflation. I know it's very complicated. Welcome to tax law, but that's just how all of that works. So that $10 million for an individual adjusted for inflation that was passed under the 2018 Tax Cuts and Jobs Act, for 2020, that amount, when it's adjusted for inflation, is 11.58 million for an individual, and double that amount for a married couple. So what this means from an estate planning perspective is that you need to, when you're creating documents, for example, when you're creating a trust, you need to put language in there that gives flexibility to your successor trustees so that they can create a structure that will help to reduce the tax burden that the state will face. There are always options available that you would want to speak to a financial advisor, a tax preparer, a CPA, accountant, whoever you trust with those type of decisions. To discuss what some of these options are, you would want to consult an attorney in your state to discuss what options are available for you in that state. Thank you for joining me for this video. I hope you learned something from it. I hope that you have a better understanding of how these two tax work hand in hand and how you can use them as a tool when it comes to your estate planning approach and what you're going to be doing. Do you need to worry about it at all? Is your estate below the exemption amount? If it is, great. If it's not, that's okay too, because that's not a bad problem to have. It just means that you have to be a little bit creative as to how you're going to go about dispersing your estate to your loved ones. There is also a generation skipping tax that I did not cover in this video. I will cover in a future video, but stay tuned for that. And please feel free to put a comment in the comment box. The comments are public, so keep that in mind. Please don't put personal information in a comment. And also like and subscribe to my channel. I hope to bring more educational videos in the upcoming weeks. I look forward to seeing you in the next video. Thank you so much for joining. I'll see you next time.